myself because now I have a echo. I was just thinking about how I got to take this out. We, in this time, okay, let me turn these off. You can at least hear me.
Yeah.
Yes.
About 6-7 months ago, we were used to meeting in a certain way and giving talks and things like that. And then everything changed. I don't know about you all, but prior to March of this year, I don't know that I even knew what Zoom was. I think I was familiar with video conferencing, but I'm almost out. Okay. I should be able to hear you all now.
You're good.
Somebody say something just so I know if I'm...
You're good, Jeff.
We hear
you well.
We hear you loud and clear.
Okay, I'm sorry, you all. I had all that time to get everything all ready, and then it wasn't going to work with those headphones.
No problem.
So yeah, doing these things over Zoom is new, but at the same time, I feel like a lot of people have become experts in a short amount of time, and some people are really unfamiliar. I'd say I'm probably somewhere in the middle. So of course, I had the bright idea as being at best an average Zoomer to try to do something a little bit ambitious. And so if you'll notice, I'm actually connected to you all in 2 different screens. So one is this one, I'm looking at you now. And the other is this one. You see my finger pointing there. The reason I'm pointing out that is I want to talk to you all about a few things on the computer screen and be able to show you some things, but I'd also like to show you a few things around the courthouse to help illustrate what I'm talking about. And to do that, I wanted to be mobile. So we'll see how that goes. But I did want to say, to start off, it's a pleasure to be back here with East Chapel Hill Rotary Club. Almost 20 years ago, I came and spoke to the East Chapel Hill Rotary Club. Before law school, I worked for a nonprofit called the North Carolina Center for Voter Education, and I came to talk to your Rotary Club about some judicial election reforms that we were working on, including nonpartisan judicial elections, optional public financing for certain judicial elections. And I'll let you all know the good news is that all of those things actually ended up happening. And the bad news is that in the last 10 years, they've all been dismantled and they're not the law anymore. But we'll see. Who knows? I will say, as I'm going forward, that it will be more helpful for me if there can be some interactive element to my talk. And so what that means is I may say some things. If you have some questions or some comments, please feel free to interject them. I see 3 ways that could be done. One is I assume there may be a way to virtually raise your hand. If not, I hope it'll let me do this. I've put you all on the wide thing so I can see you. So wave your hand and ask a question. Well, yes, thank you for waving your hand now. But if you have a question or a comment, please feel to just physically raise or wave your hand. If you want to interject something. Or if that doesn't work, just unmute yourself and start talking. So I feel like this is an time to talk about criminal justice. Like a lot of things, changed a lot in what I do. But I feel like before I do that, it might be helpful to give a basic idea. I've been surprised a lot of times people don't know what I do, what an assistant district attorney is, and some of the sort of basic things about the way court works. Just as a general idea, we'll try the waving hand things. Wave your hand if you are an attorney, either licensed or retired. Okay, I see DG Martin waving his hand. I see a couple others. And keep your hands up and waving if you're a criminal lawyer. And the reason I ask that is those of you know that just like a lot of things, there's specialization. And so I suspect that there might be a lot of just sort of things you might not know about how criminal justice works. The assistant district attorney, I work at the pleasure of Jim Woodall, who is your elected district attorney. He has been for the last 15 years. He was appointed first in 2005. And then there are 10 of us that work under him as assistant district attorneys, 7 out of the Orange County office. and 3 out of the Chatham County office. We're a 2-county judicial district. And like I said, he is elected and the rest of us are appointed or hired. And I've been working in this work for almost the exact same amount of time as Jim has been DA. About 15 years is how long I've been assistant DA. And I am from this area and grew up in Chapel Hill, and actually I'm also a graduate of Chapel Hill High School, and I'm pretty sure I went to high school with some of your children, just judging by the last names. The basic function of a district attorney is to represent the people of the state of North Carolina in criminal cases. When somebody's charged with a crime, they have a lawyer either appointed to them if they can't afford one, or they hire one. And then you all, the rest of the people, have a lawyer to represent them. Another thing that I sometimes share with people that surprises them is kind of the role of the DA is not the same as what some people think, which is that once somebody's charged with a crime, my job is to do what I can to get them convicted. Not quite that simple. In fact, I was having a conversation with a friend one time who's a well-educated man. And he asked me, you know, what's it like if you get a case and you know the person's innocent and you got to still, like, you know, go to court and try to convict them? And I told him, well, the good news is I don't have to do that. In fact, it would be against my oath to do that. When someone's charged with a crime, my job is to evaluate that charge, decide 2 basic things. One is, do I think that they did it? And 2, do I feel confident that I have enough evidence to prove that they did it? The answer to either of those questions is no. It's my duty to dismiss that charge and not proceed. If I do think that they did it, then it's my job to seek appropriate accountability, which isn't necessarily always convicting them of the top crime that they're charged with. Sure, you can surmise that there are sometimes that people in this district who get a relatively minor crime and they're young and it's their first offense. Well, we have lots of programs where those people can get something like a deferred prosecution, where they agree to do certain things and exhibit good behavior over a certain amount of time, and they might get the charge dismissed. That doesn't mean that I'm dismissing it because there's lack of evidence. I may feel confident there's plenty of evidence and they committed the crime. But justice is served better by giving that person an opportunity to not have a criminal record. And certainly there's variations of that where someone's charged with a certain crime, and I might be able to prove that higher level crime, but I think it's more appropriate to plead that crime or offer a plea to a lesser charge for a variety of reasons. To that, I'm going to show you, I just have 2 exhibits that I want to show you. So I'm going to share the screen to do that. The crimes are generally broken up into 2 broad categories, felonies and misdemeanors. What I'm sharing with you now is the misdemeanor sentencing chart. And it works just like a lot of charts that you know, which is on, there's an x-axis and a y-axis. And I think, can you all see my cursor? Not? Yep. Okay. Yep. Okay, so along here, you have the level of crime. Least serious is class 3 misdemeanor, 2, 1, and up to A1. Examples of class 3 misdemeanor are second degree trespass or possession of a small amount of marijuana. Examples of A1 misdemeanors are assault on a female, misdemeanor stalking, and there's several, assault on a law enforcement officer. And then there are several things in between. And that's how the misdemeanors are arranged. So these are the seriousness of offense, and then across I call this the y-axis, right? And then across the x-axis here is their record. And so every time somebody's convicted of a crime, they accrue certain number of prior conviction points. And then so you basically can intuit out here that the more serious the crime / the more serious the person's prior record, the more serious punishment they face. And just to let you know, the CIA, community punishment means probation. A means active punishment, that means jail. And then intermediate means a mixture of the 2. So that's the kind of punishment people can get for misdemeanors. Before I leave that, anybody have any comments or questions about that? It's okay if you don't. And let's see, exit, share. Wait, stop share, okay. And then one other thing I want to share is the felony sentencing chart. And it works the same way along the y-axis, you have the seriousness of offense, and then along the x-axis, their prior record. The I felony is the least serious felony. Example of that would be breaking into a car. We call it B&E of a motor vehicle. And the most serious would probably is obviously an A felony, and that's first degree murder, and that's the only offense that's an A felony. And then there's a lot of things in between. D is an armed robbery. H is breaking or entering into a building, and lots of other crimes there. And you can see, and these numbers represent numbers of months of punishment, not years. And similarly, you can get community punishment, probation, you can get active punishment, and you get a mixture of it. A couple of fun facts. There, like a lot of things, there's weird quirks in the law. So, for example, and I want to make sure when I make these are just for fun illustrations. I'm not suggesting you do any of these things, but the other day, a friend of mine was saying they have a next door neighbor that has a dog that's really bothersome, and they asked me what would happen if they killed that dog. I said that I told him, oddly enough, like if you kill a dog, as long as you do it quickly and don't torture it, that's a misdemeanor. But if you steal a dog, that's a felony. Don't do either of those things, but surprising, it's different. Another weird quirk is that simple assault is a class 2 misdemeanor, and communicating threats is a class 1 misdemeanor. So if you tell somebody, and somebody asked if this was kid friendly, they probably would see this on a PG-13. You say to somebody, you know, I'm going to kick your ass. That's a class 1 misdemeanor. You get up to 120 days in jail for that. But if you just kick their ass and don't say anything about it first, as long as you don't hurt them too bad, that's a simple assault, class 2 misdemeanor. So don't do either of those things, but if you're going to, don't say anything about it before you do it. And finally, there's one other quirk about possession of a small amount of marijuana, like I said before, is a class 3 misdemeanor. But the bag, if you put it inside of a bag, that's drug paraphernalia. That's a class 1 misdemeanor. And so oddly enough, the bag that's holding the marijuana is a more serious crime than the marijuana itself. So I guess if you're going to handle small amounts of marijuana, if you have large amounts, it gets more serious. But if you're going to have under a half ounce of marijuana, just hold it in your hand. Don't package it with anything. I will say that is a quirk that they have fixed. I see a hand up, and it's sorry if it's been up for a while. I'm only seeing it on my side screen and not my. Karen wants to say something.
Yeah, it was on the first chart on the misdemeanors.
Sure.
The person, it looked to me like even if the person had 5 prior convictions, what's happening? Can you hear me? It looks like my internet. Okay. It looked like even if the person had 5 prior convictions, they were just getting up to 150 days.
Correct. On misdemeanors, that's right. Most you can get on the most serious misdemeanor is 5 months in prison.
Wow. Okay.
And to be candid, these are the maximums, and it's pretty rare that somebody gets the maximum. But again, remember, those are misdemeanors. Obviously, you saw the felony sentencing chart, and the punishment can be more significant when you commit more serious crimes. All right, let's see. I will put you all back in the gallery view. Is that me? Okay. All right. So I get a case. Okay. I'm muted on one. Is anybody logged in twice?
I fixed it. We're good.
Okay.
Keep going.
When I get a case, I basically have to make a decision, and to kind of get onto the meat of what I'm here to talk about is why things are different now. So when somebody's charged with a crime, they get a lawyer and I get the case, and I decide what's the most appropriate thing to do with it. And typically what happens is I evaluate the case, and I take into account what I consider, I always talk about it as the good, the bad, and the ugly. The good is, what are the good things that could be said about the person charged with the crime outside of what they're actually accused of doing, other positive things about them. The bad is, how bad was the crime? And you might say, well, we have a chart there that shows how bad the crime is. But even within certain crimes, there's variation. For instance, armed robbery could mean someone holding a small pocket knife and waving it around and saying, give me your money. Now that's bad, that's serious, but could also mean, you know, a shotgun to the head of someone. This is why I said it's a little tough for kids, but I'm talking about crime. So, you know, pressed up against somebody's forehead, cocking the chain, you know, the whatever back. I'm not a gun guy. You know, and telling them, you know, give me all your money, I'm going to blow your head off. Those are both the same crime, but obviously you can sort of figure out that one is more significant. And so that's the bad. Good, what can be good about, and bad, how bad was what they did. And then the ugly really is a weird analogy, but there's no movie called The Good, the Bad, and the Nitty Gritty. So the bad just means the nitty gritty. How strong is the evidence that they did it? How solid is the case? For instance, obviously using that armed robbery analogy, if you have that really bad armed robbery, but your only witness to it is a person who was, you know, admittedly using drugs at the time and had a personal bias against the person who is who's charged, and it was dark and they didn't get a very good look at it, versus the less serious armed robbery, but it was caught on video and the person confessed after being Mirandized. That's, so obviously you can see that those kind of slide around on scales, and I kind of take all that into account. Obviously, considering their prior criminal record, which shows what the punishments are available, and I'll usually make some kind of a plea offer to that person, an opportunity to settle the case, like they do in all kinds of legal cases. And this is kind of where the COVID change affects a lot of us. Now, if I make a plea offer and it's accepted, that in the current world goes pretty well, although differently. We, like a lot of you, are doing our work over Zoom, and we actually use WebEx, but it's basically the same thing. And oddly enough, I've pled out many cases where I'm sitting at my desk or even at my kitchen table, and the judge is sitting in his or her living room, and the defendant's lawyer is sitting in her living room, and the defendant is sitting on their couch or in their car on their phone, and the court reporter is sitting in her house keeping track of things, and we plea out the case the same way, but nobody's physically in the courtroom. Those go pretty well. I'm pretty proud of some of the things we're doing to move that along. And I think it's probably an innovation that we will continue to use on some level. Sometimes many people have jobs that involve what they call herding cats. That's what court is like a lot of times. Is one of the things that slows things down is just getting all the people in the courtroom. Well, we might not have to do that as much in the future. But where it gets tricky is if we're not able to reach an agreement. And then obviously you all know that what tends to happen then is if we can't come to a compromise, then we would go to trial. Trials involve people. They involve a lot of people, and pretty much definitely involve people in person. To illustrate that, I'm going to show you all around the courtroom some. So I'm going to see if this works. Can you all see this version of me goes to spotlight your video? Oh, see, look, and unmute, and then okay.
Mute the other one. Mute the other one. Unmute the iPhone. Mute the PC.
It is unmuted. That's weird. It's probably a setting on your phone itself rather than Zoom. Because on Zoom,
Weird.
yeah, we can't hear you, Jeff.
Okay, can you hear me now?
Yes, there we go. Perfect.
Okay. Sorry.
Oh. So that was your computer.
I'm gonna do that. And all right, can you hear me now?
Yes.
Okay. Sorry, y'all. I really am. I thought it'd be helpful to be able to show y'all the courtroom, so I'm gonna try this. I see that Brian is raising his hand. Brian Keeliff, that's what I was talking about. I knew I went to high school with somebody's child. Brian, what did you want to say or ask?
All right, thank you. Jeff, yes, I'm not sure which daughter, but I remember your name too. I'll have to find out more about you when I speak to them this evening. Jeff, you talk about crimes being different, or the same crime, same designation, but if it's the penknife or if it's the gun, it's different. Tell me about equal justice for blacks and whites.
Whoa, okay. Sure, that could be a whole talk in and of itself.
I know, but I'd really be most interested.
Okay. It's a pretty broad question. Let's see. I would say that broadly speaking, I do believe, and we learn in training about the fact that there does exist institutional racism, which disproportionately affects people of color from the beginning of the judicial criminal process to the end. That I would, a lot of times people, in fact, I would say even this, that it affects people prior to the point of arrest. So the criminal justice process, you might say, starts at the point that the person is stopped, and that can be in a car or on foot, but the initial law enforcement contact. But really, most people would agree that institutional racism affects criminal justice outcomes starting even prior to that, obviously. So institutional racism affects people's financial circumstances, and therefore it might be more difficult to have your car inspected and properly registered. Well, if a car isn't properly inspected or registered, then that is a lawful reason for a vehicle to be stopped and can increase contact from certain people with the criminal justice system. But obviously I'm assuming you're asking more about like when it comes to when people come into the courtroom.
Yeah, what do you do about it, Jeff? Because you recognize that happens. So what's your role, and what do you do to try and counteract that?
Well, I think that probably, so I'm in spotlight again.
I hope this doesn't, it did.
You know what, I'm gonna go back to this screen here because I won't get confused. So what I do, I have taken implicit bias training and then racial equity training, and try to be conscious about being sure that I don't make decisions based upon race, or at least not in a racially discriminatory way. I think probably anybody who tries to make the statement that they're color blind is probably, in my personal view, is not the best way to go about it. It's okay to be aware of race, but not discriminatory when making decisions. So, you know, Brian, I feel like the best thing I can tell you is that I try my best to be conscious of, try to avoid, and like to think that I have, stay free of explicit conscious bias, and then be as aware of as possible of implicit and unconscious biases that I may have, and just be conscious about those things when I make decisions. And do my best to apply the facts of the case and the overall circumstances of the defendant in a fair and unbiased way. I mean, I guess I could talk about some, this is why I love that you're asking about this, but I could talk about some sort of more broad systemic things that I've done over my career to try to ameliorate systemic bias. And, you know, I guess I could talk about that, but it means I won't get to COVID and how we're doing things differently.
Well, keep going, but thank you for starting on it anyway.
Sure. Yes, Jelaine, my second.
It's Peggy. Sorry, it's fine. I go by Peggy. I have a quick question.
Sure.
Plea bargaining. Okay, when somebody is appointed a pro bono free lawyer, it seems to me like they're much more likely to try to get a plea deal than a lawyer who's going to get paid for his time and the outcome. And what that does, I think, for people who don't have enough money, is it tends to make them accept a lesser crime conviction, even if they felt that they wanted to plead innocent to the more important crime.
Okay.
So how do you deal with that?
Good question. I guess I would say that I think that fortunately, that is a perception that is reasonable for you to have, and I would say that it is. I don't want to say like I'm being critical because, like I say, it's a reasonable one to have, but it's not true. The court-appointed lawyers. First of all, I'll say this: my father's a public defender. He's the public defender in Guilford County, and I worked in some criminal defense as a law student. When I say this, take that into account. The public defenders typically tend to be among the most talented criminal lawyers in the courthouse. And I say that also several of my best friends are private lawyers, so I'm integrating them. But I will definitely say that it is an incorrect perception that the sort of typical thing is that court-appointed lawyers, public defenders, or court-appointed lawyers are these sort of beleaguered / overworked / underexperienced lawyers who are just trying their best to push the paper across the table and get their cases done because they're overwhelmed and understaffed and resourced. That's just not my experience. And there's certainly plenty of private lawyers who also are very talented and well-staffed and well-resourced. So I'm not saying that the opposite is true, but I'll say is that you can't expect that people are getting different justice because they have court-appointed lawyers versus private lawyers. They might get different representation because the individual happens to be their lawyer. I'll just say that the public defender does not, and I will say this, they're not technically free, and this is certainly a far-flung debate that we could have about where they should be, but technically if you end up getting convicted, you do have to reimburse the state for the cost of your lawyer. It ends up being between $55 and $75 an hour, which is not chump change, but is significantly less than what typically a private lawyer costs. But all that's to say is that that's a well-held and understandable conception, but I would say it's a misconception. And the public defender's office, particularly in this district, are without question some of the best lawyers that anybody could get. So I was about to sort of illustrate if we go to trial thing, I'm going to try without changing any audio, just going to swap this around and show you the anatomy of the courtroom. So if you can look, yes, so I kept the audio the same. So for one, this is able to illustrate to you some of the physical changes in our courtroom. I'm going to go like this. So you can see that this is the defendant's table. Now, I think you can tell that there's a glass divider there for COVID safety between where the attorney and the client would sit. There are glass dividers on each side of the judge's bench. You see up there, where the judge sits. And then you can see obviously over here on the state's case, although I don't typically sit with the client, but if two people are sitting here, they can be separated. No changes yet to the jury box. So that's where the jury box. And the reason I wanted to illustrate this physically was to show a few things about why COVID makes trials so hard. Right now, I'm showing you the witness stand, which is next to the judge's bench, and in front of it is the court reporter's stand. The reason that that's there is because the court reporter needs to be as physically close as possible to be able to hear the things that are being said. Obviously, being close physically to people right now is really difficult and causes problems. Also, second only to the court reporter is the jury box. The courtroom is set up to have the jury box in the closest possible place to where the witness sits in order for them to be able to not only hear the witness, but also to judge body language and demeanor, and to be as close as possible, be able to hear them. Well, that creates two problems, obviously. One, they're all close to each other. Two, they're close to the witness and the other court personnel. So some people have suggested that perhaps we could do it differently and get real good audio, visual stuff in the courtroom, and have the jury spread out here in the gallery, out here, you see. And that is actually how we do grand jury. Grand jury is a different kind of jury that decides on indictments. And that's different because it's a different process and you don't have the same requirements. So for whatever it's worth, we are running grand jury that way. But you really can't run a trial that way with people distant. Now we might try. When I say you can't, it's difficult. Now, that doesn't even get us past the whole idea that you have to select a jury, which means you have to bring in usually between 60 and 70 people. And the previous plan was to show you the jury lounge, a couple other things, but we're clearly not going to get there. But bring about 60 and 70 people in, you file them into this courtroom. They sit usually on one side, and because all the other people and witnesses always sit on the other side. They're packed in together and they start getting called up. Certainly can stand to reason that you might suspect that there are some people who get jury summonses who might not be that ecstatic about serving on a jury. I'm sure that wouldn't be the case with the folks in this group, but it is with some. And you could also imagine that among those people, and also this could be said genuinely, of course, somebody raise their hand and say, Judge, I want to do my duty, but I help take care of my 80-year-old mother. You can't expect me to put my whole family at risk. And what judge wouldn't feel pressure to grant that request for, and then quickly would cascade. So I realize that I think I'm supposed to stop by 2, so I'm going to sort of shortcut and just say, having jury trials right now is very difficult. And what that means is, even though we are able currently to find plea agreements on a very high percentage of our cases, but we don't try all of our cases. You might say, well, why can't you do the non-trial cases? The problem is that the specter of a trial, the presence of the possibility of a trial is what helps move those other cases. The fact that both sides, the trial is the ultimate calling of the bluff for either side. The defendant saying, oh, well, fine, prove it. You think you have this evidence can be, go to a jury and convince 12 people beyond a reasonable doubt. And on the state side, you might say, look, you plead guilty and you could get this less punishment. Oh, well, if you're not willing to do that, well, then take the risk of this higher amount of possible punishment. But right now, neither side can say that credibly because we can't schedule trials because of all the difficulties in putting in a jury trial. So it changes the dynamic and it makes moving cases a little more difficult. We're working on a plan to make jury trials more possible. And obviously, once we have vaccines and more therapeutics, like a lot of other things, we'll get back to normal. But until then, we're doing the best that we can to move cases through. And I'll finish to explain this in one more analogy, I guess. If you think of our court system as kind of like a bathtub, and the cases coming in are like water flowing into the bathtub. And believe me, I'm not the real people, but it's just, it fits the analogy. Cases come in at like water in the bathtub. Well, right now, because we can't move cases out as well because we can't try cases, the drain is clogged. However, good news is that for arrests are way down, charges are way down, so the drain is clogged too. We're not quite yet getting too overloaded in the court system because we're sort of plugged up on both sides, partially plugged on both sides, but it could, I guess it's slowly filling up. And the reason that the faucet is clogged is 2 primary reasons. One, COVID means that people are not out and about in the world as much. And I think people sometimes think that crime involves 4 guys sitting around a kitchen table and cooking up a diabolical scheme to commit a crime, and then they get together and make a plan and go commit a crime. It's actually rarely like that. It's much more often opportunistic and spontaneous. People are out in the world and they literally or figuratively crash into each other and stuff happens. We have a lot fewer people out in the world now, and so there's just less opportunity for there to be those kinds of interactions where crime happens. And then obviously, because of the social changes that we're going through now after the murder of George Floyd, we are seeing a rethinking of policing. And so there are many things that are being done to reduce interactions between police and the public, which are bringing charges down in that sense too. And so that kind of summarizes where the court system is now. And I think I've gone over time, but I'm certainly happy to answer any questions.
Jeff, thank you very much for sharing your time with us. Very interesting. We appreciate all that you do in our community and for your work. And grateful for you sharing your an hour with us today, and appreciate you putting up with our banter before your talk. So we're grateful for you being a part of our group today. Wish everybody a safe weekend, and look forward to catching back up again with everybody next Friday.